Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Attorney Files RICO Civil Rights Suit Against St. Louis Family Court. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also, if you're new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these power videos. So without further ado, let's get to it. Okay, before I read this article on the screen, I would like to give a special shout out to my ARC, Mr. Rogers, who sent me this article. So we're going to go over this article in its entirety. I will give my opinion on what I believe will transpire in the case and what the outcome will be. So without further ado, let's pick this thing up at the top where it states, Attorney Files RICO Civil Rights Suit Against St. Louis Family Court. The date of this article is August 14th, 2025, which is this month, this year. Let's continue. It reads, St. Louis, a Missouri attorney has filed a sweeping federal lawsuit accusing multiple state officials, family court judges, commissioners, attorneys, and guardian ad litems of participating in an organized criminal enterprise within the St. Louis County Family Court. Then it states, the suit filed in what? In the U.S. District Court of the Eastern District of Missouri. So you guys know what I think about filing suits in the U.S. District Court, especially when you are already a state court loser, okay? There are laws put in place that a state court loser cannot use the U.S. District Court as a court of appeals. So anytime you lose in a state court and you petition the U.S. District Court, you're going to automatically lose, guys. Okay? That's why there's no evidence of no one winning in federal court till this day. Despite what all these people are claiming, like other channels and stuff claiming that you can file a federal lawsuit, but you ask them to show proof of anyone winning a federal lawsuit, you're going to get crickets and excuses. That's it. A bunch of excuses, but there is no evidence of that. But let's continue on. So again, I advise you guys, stay out of federal district court. I even advise this attorney who filed this suit to stay out of the U.S. District Court. Why? Because they will rule against them, claiming that what? 14th Amendment immunity, and they're going to also rule Rooker-Feldman doctrine, and they're going to file a 12B1, 12B6 motion to dismiss the claim, and it's going to be dismissed immediately. But let's continue on. It states, invokes the Racketeer Influence and Corrupt Organization RICO Act and the Civil Rights Act, alleging systematic corruption, extortion, wire fraud, obstruction of justice, and perjury designed to manipulate custody outcomes for financial and political gain. Then it states, Matthew R. Grant, a former litigation partner at one of the 100 largest law firms in the United States and founder of Stop Missouri Corruption, contends that the alleged enterprise, dubbed in his complaint as the Clayton Kids for Cash scheme, retaliated against him for exposing corruption, culminating in the loss of nearly all custody of his teenage sons despite his proven sobriety and prior history of joint custody. Before the legal battle began in March 2024, Grant shared equal custody, averaging about 15 nights a month with his two children, according to the complaint. After publicly raising corruption allegations in the Missouri Court of Appeals and Missouri Supreme Court, his custody was reduced to one overnight per week and is now at risk of being cut to 2 nights per month. The lawsuit named numerous defendants, including St. Louis County Presiding Judge Mr. Hilton, former Commissioner Mrs. Greaves, guardian ad litem Mr. Finley, the children's mother Mrs. Copeland, her attorney Mrs. Brody, 2 relatives of the children, and others. Grant alleges that Finley attempted to coerce him in a recorded June 2nd phone call offering to restore custody if Grant would publicly recant his corruption claims. When Grant refused, he says Finley retaliated by recommending further custody reductions. Grant asserts that the defendant have used false pleadings, fraudulent court orders, and perjury to justify restricting his parental rights and to punish him for refusing to settle on terms favorable to the mother. So again, by that statement alone, guys, he is now talking about what? He's talking about the custody order. So once he's in these federal district courts and he mentioned anything about custody, it's going to be a wrap. The minute he say the word custody, they're going to construe his complaint as a state court litigant who lost in state court, who's trying to use the U.S. District Court as a court of appeals, and it will be thrown out for failure to state a claim upon which relief can be granted under Rule 12b1 and 12b6, and the people that he are suing in the federal district court has judicial immunity, and that will also be thrown out as well. But let's continue on. He states he cites a series of incidents, including what he calls fabricated allegations from Copeland during trial, such as claims of sexual coercion and threats to harm the children, that were never raised in deposition or earlier testimony. So again, you still see, guys, he's going back and forth talking about the children. That will not suffice in the U.S. District Court. But let's continue. It states the complaint alleges that the corruption is long standing and protected by political connections, including ties between judges and attorneys involved in the case. Grant claims he has obtained text messages, court transcripts, recorded conversations, and internal communications as evidence, and that he plans to present witnesses from other cases who experienced similar patterns of conduct. He also claims the scheme exploits children as leverage in custody disputes to generate excessive legal and guardian ad litem fees, forcing unfair settlements, and retaliating when parents resist. Grant filings describe prior efforts by others to expose similar conduct that failed due to judicial immunity defenses or insufficient pleadings. So again, guys, that statement alone, let's read it again. Grant filings describe prior efforts by others to expose similar conducts that what? That failed, you see? Failed due to judicial immunity defenses and insufficient pleadings. So, everybody else who files them, they all fail for these same reasons. His lawsuit is no different, guys. But let's continue. It states he argues that as an experienced attorney with a background in class action defenses, he has drafted a complaint that meets the legal standards to overcome those obstacles. The case includes class action claims on behalf of others alleged victims of the enterprise. So he has to try to beat the Rooker-Feldman doctrine, guys, which he will not do. Okay? So as much people claim that you can go in these federal courts and sue the state agency, the attorneys, the judges, and everything else, we never see any victories. Why? Because immunity and the Rooker-Feldman doctrine blocks all that at the gate. So that's why I tell you guys, like I always tell you guys, stay out of federal district court. Anyone telling you guys to go into federal district court and think you guys can win a lawsuit, you guys are sadly mistaken, and you will be in for a rude awakening. Stay out of these federal lawsuits. I cannot stress this enough. Beat them in the state. Fight them in the state. We get remedy in the state. But let's continue. The Missouri Supreme Court previously intervened in Grant's underlying family court case in March, issuing an order sui sponte, which Grant calls unprecedented and indicative of the seriousness of his allegations. Despite this, he says retaliation has continued and he remains under a gag order prohibiting discussions of the case with his children. Grant seeks injunctive relief to reform court practices, damages for harm suffered, and oversight of an impartial federal judge. He maintains that this case is not about a custody dispute, but about dismantling what he calls an organized criminal enterprise operating under the color law in Missouri family courts. So again, guys, why do you think he said this? Okay? Why do you think he keeps saying that he maintains that this case is not about custody disputes? Why? Because he knows deep down inside it is about custody disputes. Because if it wasn't a custody case, he wouldn't be in federal court. Okay, remove the custody case and he has no claim. So his claim is strictly about the custody case. Okay, and by that being there alone, the Rooker-Feldman doctrine applies and he automatically loses. And Rule 12b1, 12b6 for failure to state a claim upon which relief can be granted will be ordered and will rule against him, and the case will be thrown out. So if the attorney watching this, he need to get understanding of what's going on. It's not what he think it is. Now he probably did many of criminal cases, but it's a different criminal matter when you're going against these family courts and how they have these things set up. Okay, it's a major scheme going on, but he's going about it the wrong way to get justice. But let's continue. It states this case is not about a custody dispute, Grant said in a provided statement. It is about dismantling an organized criminal enterprise operating under the color of law in Missouri family courts and restoring constitutional rights to Missouri families. So again, that's the end of the article, as you all can see. So we went over the whole article. So my take from this is he will lose this suit based off the Rooker-Feldman doctrine, and that the people that he is naming have immunity in U.S. district courts. So his proper step he should have did. Matter of fact, I'm not going to even mention that. That's for those who want help. But in the meantime, in between time, he filed in the wrong court. I'm going to also do more research on his case. I'm going to actually get the actual case so we all can read what's going on in that actual case, just to give you all more proof on why I say stay out of federal courts and why there is no evidence of no one winning in federal court or federal U.S. district court, because they have everything sewn up, and the Rooker-Feldman doctrine simply ends it all right there, because state court losers cannot petition the U.S. District Court for remedy or try to use the U.S. District Court as a court of appeals after they lost in state court. Okay, so again, that's what I'm gonna do for today. If you all need my help, hit me up at my email at y'allismagnified@gmail.com. I have more testimonies coming soon, guys. We're applying a lot of pressure, guys. Things are stepping up. If you guys think I did big things back then, hold your horses, guys. I'm trying to tell you, I'm on a totally different level. We're up in our game. It's going crazy, guys, and it's coming real soon. Testimony's gonna come in back to back to back to back. Remember, guys, you heard it here first. Today is the 19th, August the 19th. Watch how many testimonies come back to back to back to back in the near future, guys. Time to apply that pressure. We taking over. It's over with from here on out. With that being said, again, you all be blessed. Like, share, and subscribe. And I say shalom.